Welcome, everyone. I think everyone's just being admitted from the lobby, so I'm just going to do a quick introduction, but it'll sort of be rolling as we have new people joining. Just by way of introduction, some of you will know me already. My name's Alex Harper. I'm a senior solicitor in the employment team. And today I'm being joined by Cassie Blackledge, who's a solicitor in our team, as you can hopefully see her in the corner of your screen. And today we're covering navigating senior exits. So we're looking at the legal and strategic and practical considerations. I'm just going to give it, before I do the full agenda of what we're going to cover today, I'm going to give it a few more minutes just to have maximum attendance guaranteed at the beginning, and so that no one misses out on anything. I'll also do a couple of housekeeping points while we're waiting, which is to say, please do participate as we go through slides. I'm absolutely open for this being a discussion. So if you want to raise a question, then please do as we go through. There will also be time for questions at the end. So if you'd prefer, you can keep your question and have it in the chat or the Q&A box and raise it at the end. So it's completely up to you, either questions as we go or as and when the questions slide, as and when the question slide comes up, then it's a free-for-all and you can all ask as many questions as you like. I think we've probably got most people now, and because there is quite a lot to cover in an hour, I will take you through that. So to start with, what are we going to look at today? We're going to start with senior level concerns, and there's a couple of slides on this just as we look through kind of some of the practical and the commercial concerns and move into some of the more legal and contractual concerns that that arise when you're exiting someone at a senior level. We're going to look at without prejudice and protected conversations, looking at some of the differences between those. Of course, we're going to cover settlement agreements. As many of you will know, it is very common for senior exits to be agreed via a settlement agreement. And then as we cover settlement agreements, we're going to look at the kind of commercial and legal negotiations that go alongside that process. We're going to look at the practical considerations of managing that settlement process, and also look at the kind of common legal pitfalls of senior exits, and looking at that particularly through the lens of settlement agreements, but also just how it can go wrong in other scenarios too. Just for the late joiners, as I've said, if you have questions, please feel free to pop those in the chat box as we go through. Otherwise, there will be time for questions at the end. And with that, I'm going to pass over to Cassie to take you through the first kind of set of concerns around the situations in which senior level exits may occur.
Thanks, Alex. So yes, as Alex has mentioned, it's important to understand the legal and practical context behind why an individual of a senior level may be exiting the organisation. And those exits can happen for a number of reasons. So we've got the top there, a legally fair reason, and that might include capability, conduct, redundancy, a breach of a statutory duty, or for some other substantial reason, also known as SOSR. And these are recognised under employment law as valid grounds for dismissal. Alternatively, a senior individual may choose to resign voluntarily, or their exit may be managed through a settlement agreement. And settlement agreements, as we've touched upon, are used in both sensitive and complex situations, and essentially both parties are agreeing to part ways on mutually acceptable terms, and they often provide clarity, confidentiality, and a clean break between the parties. Next slide, please.
Sorry, I'm a bad slide assistant. Apologies.
So here we have a range of senior level concerns and things to think about. So the process when an individual leaves, particularly when they're senior, is rarely just transactional. There are deep concerns such as reputation and legacy, succession and transition planning, and then personal and emotional considerations to consider as well. And if we just take each of those separately, so first of all, we've got reputation and legacy. So more often than not, senior individuals will have a long-standing presence in the organisation. They'll have been involved with shaping the culture, the strategy of the business, and building external relationships as well. And their reputation and legacy are often front of mind during an exit. So it's understandable that they're sometimes concerned or could be concerned on how their departure will be perceived by colleagues, stakeholders, and even the wider industry. We then have succession and transition planning. So it's known that senior individuals will hold critical knowledge, relationships, and strategic oversight on the organisation. And they might be worried about how their exit is prepared for, and whether or not a success has been identified, whether or not key projects will run smoothly, and whether their teams might be supported following their exits. So it's very important that we have a well-structured transition plan or a handover in place to ensure that there's continuity. And then finally, personal impact often gets left behind, but it's very important. For many, leaving a senior role is a significant life event, particularly where someone's identity is closely tied to their position within the organisation. So there may be feelings of loss, uncertainty, but also there's sometimes feelings of relief as well, depending on the circumstances. So it's common that there'll be anxieties about future career steps, financial security, and adjusting to a new routine. And these should also be factored in when negotiating an exit, to ensure that any exit's handled with empathy and discretion where possible.
Yeah, I think that's right. Thank you, Cassie. I think that's right. I think personal and emotional considerations is a big thing that often gets overlooked, and particularly can factor into how you manage an exit. So, we spoke briefly on the previous slide about legally fair reasons for terminating. All of you will be really familiar with those. And often, because someone's so senior and they have such a large amount of goodwill within a business, or they've got the personal relationships, that any of those routes may not always seem appropriate. And that's where, going through a settlement agreement tends to come in and tends to be the way that a senior level exit is approached, unless, of course, they've resigned, which might be because a personal situation has arisen and can't be potentially resolved. So there are lots of concerns that Cassie and I are taking you through now on these two slides, which not only kind of inform which process you go down, so whether it's going through a legally kind of fair reason process or whether you go through a settlement. I think it is really important to consider the kind of personal connection there. And then moving into some of the more kind of legal elements, if you like, of an exit, which may sometimes determine how you exit someone. The first thing is thinking about the financial and contractual entitlements that a senior individual may have. There are lots of elements here to think about, and often it goes beyond what's just written down in a contract, particularly with senior people. So if you're going through one of the legally fair processes, so whether that be a capability dismissal or or potentially a conduct or a redundancy dismissal, and I say those because they tend to be the more common ones at a senior level, you've also got to think about how that might impact what you're paying a senior individual when they leave, because any one of those reasons could impact, for example, any kind of share platform that they're engaged in, any kind of rights they have, and if anything is subject to a share agreement, then whether or not someone's made redundant or terminated because they've committed misconduct can have an impact of how they're treated for the purposes of that share scheme. So it's something to bear in mind when you're thinking about how you go about exiting a senior individual. Thinking of other financial elements then, it may also be something that goes beyond just the salary that they're paid as part of the contract. You may have to think about commission, depending on the role, or bonus and entitlement to that, and how that's going to be managed as part of the exit process. Again, there may be impacts in a senior level exit more than kind of at the more junior end of the scale, where your bonus scheme says if you're subject to a kind of investigation or a performance process, you're not eligible for the bonus. Now, for a junior individual, that might not be the be all and end all, but for someone at the senior end of the scale, if the bonus is substantial, that might significantly impact how you navigate that. Thinking about the legal protections and the risks, Cassie's touched on these already. You kind of got to think about how you're managing the exit, succession planning, having everything in place. But that can take another level when you're looking at someone who's senior and has significant connections, maybe is critical with certain clients, or has a role which means they're business critical for whatever reason. It may be that going down a legally kind of process-driven approach to exiting them isn't going to work for you, because actually you look at their contract and you think their post-termination restrictions haven't been updated since they were a graduate with us, and now they're a senior exec or a senior director, that the post-termination restrictions that we've got are no longer fit for purpose, and that might be a determining factor in deciding to go down a settlement agreement. Likewise, it's thinking about things like their access to confidential information, their access to clients, their general kind of know-how in terms of what they've learned as part of the business at their senior level, and how you best protect those. And this is probably the most critical reason that people decide to go to exit via a settlement agreement rather than relying on a fair process, because if any of those kind of contractual elements are not sufficient for the senior exit, for the senior individual that you are exiting, then a settlement agreement gives you a chance to correct those. Finally, just briefly touching on regulatory and governance implications. Now, this isn't going to apply to every sector, but for those of you who are operating in a regulated sector, such as financial services or teaching or healthcare, there may be regulatory and governance implications of someone leaving, and it's just making sure as you navigate an exit that you're also navigating those appropriately. So taking financial services as an example, if you've got allegations of misconduct or capability, but a lack thereof, as it were, to the extent that someone's potentially being negligent in their role, there may be reporting requirements in that you might need to speak to the FCA, you might need to report something if it's significant. And there may also be things that you need to be mindful of as you're going through an investigation, for example. With the FCA, there are trigger points at which point you have to notify them. And quite often we have financial services clients who look to intervene with a settlement agreement prior to a certain point in a disciplinary process, for example, to potentially reach an agreement before an investigation has gone too far, such that a report to the FCA is required. So it's thinking about all of those things and how do we then apply those to an exit. And there may well be circumstances where doing a performance process or a disciplinary process, or even a redundancy, or even an SOSR consultation is totally the appropriate choice. Likewise, it's more unlikely at this level, but you could, for example, have someone who loses the right to work in the UK, and therefore it is no longer legally possible for you to employ them. In that scenario, it's absolutely clear cut. You would follow the kind of legally fair process. However, often with senior individuals, it is not as simple as that. And that's when we come into the kind of world of settlement agreements. And I'm just going to briefly take you through kind of the two routes of achieving that with an employee. Of course, the other thing with senior employees is that very often they will be familiar with the without prejudice and the protected conversation process. They may have had these conversations on your behalf as the company before. It does mean that these types of conversations are sometimes easier than with a more junior employee who's less familiar with the process. And so I'm just going to take you briefly through the kind of legal process of a settlement agreement. So there are two routes, as you'll all be aware, of having a without prejudice or a protected conversation. The first is, so the purpose of both is to facilitate a settlement discussion around an exit, and effectively waiving an individual's rights to bring litigation against the company in respect of their employment or its termination. Now, without prejudice and protected conversations are two different and distinct processes. However, if many of you will have worked with us before, and you will know that our absolute preference is that, except in certain circumstances, most of the time you would be having these two conversations at the same time, simultaneously, having a without prejudice conversation and also having a protected conversation. But just taking you through the differences between these, a without prejudice conversation applies in situations where there's a genuine attempt to settle an existing dispute. And therein lies the problem a lot of the time with without prejudice conversations, is that unless there is a dispute between you, without prejudice privilege will not apply. So it's difficult, particularly with senior exits where it's amicable. So perhaps a senior director has come to you and said, look, I'm looking to leave the business, I want to retire, or I want to move on and do other things. And there's no kind of bad blood, there's no dispute, there's nothing between you two that you're not on the same page about. There's no dispute there to apply without prejudice privilege to a conversation of negotiating their exit. If there were, though, then it would be easy. If there, and we like this one as a clear, without prejudice privilege is the easiest to apply when there's a very clear dispute, and it's why it's very often tacked on to a process which causes a dispute. So, for example, in a disciplinary scenario, you might start to have the conversation of, look, we've got these allegations against you. This is where we're going to start the investigation, and then move into a without prejudice conversation off the back of that, because clearly, if there are disciplinary allegations being raised early on, that creates a dispute, which then attracts without prejudice privilege for the exit conversation. So protected conversations, then, they arose as a result of the government trying to fill a gap in without prejudice privilege, and they came about through section 111A of the Employment Rights Act. They're slightly different to without prejudice conversations because there is no need for a dispute to be pre-existing when you have the benefit of protected privilege, which means, again, both of these conversations, I should say, are off the record and can't be relied upon in later legal proceedings by either party. It's just the route by which you get to that is slightly different in both cases. So protected conversations are applicable in situations where there's no dispute, but are only applicable in cases where there's an ordinary dismissal. So by that, we mean not something that relates to discrimination or whistleblowing or breach of contract. That will not be protected and off the record in a protected conversation, which is limited to that. And that's why we ask clients to mostly have both of those conversations at the same time. So you would have a conversation where you start by saying, I've set up the grounds for the dispute, if there isn't one already, by having an open conversation, for example, about a performance concern or a complaint from a client, or a breach in trust and confidence, for example, and then move into a conversation which you then say is without prejudice, but also protected pursuant to section 111A of the Employment Rights Act. That way, you've got the benefit of the protection of both, and you can say, and we encourage you to say, if it's not one, then it is the other, and in either case, the conversation that we're about to have is not disclosable in legal proceedings. As you can see on the side, what we're talking about in terms of best practice is basically what I've just said. Mark the communications that you send afterwards on the same basis, but more importantly, in the conversation before you send any kind of follow-up, say the same thing out loud, and ideally have someone take a note and say that it's without prejudice and protected. And also just thinking on that practically, one of my top tips is if you do have, or you are the note taker in the meeting, make sure that when you take without prejudice notes, you put them onto a new page. It just saves a headache down the line if you go into a dispute, because then Cassie and I are scrambling, reading through handwritten notes and suddenly have to redact paragraphs and paragraphs which are all without prejudice. And if everyone put their without prejudice page notes on a different page, Cassie and I would have much easier lives when it came to employment tribunal disclosure. So that's a personal plea from me. And then my other kind of top tip in terms of without prejudice or protected conversations is don't go too far. Don't say anything that you wouldn't want to be read out in an employment tribunal. And you can skirt the line. So, you can absolutely say, or if we go through a disciplinary process, I think it's very likely that your employment would be terminated for gross misconduct, for example, but still have those caveats. So still have it's likely. Don't predetermine a process just because you think you've got the benefit of without prejudice or protected conversation privilege, because nothing is guaranteed. And it's always far easier to use the conversations for what they're intended, which is to have a frank conversation and an open conversation, but with caution, so that if ultimately, for whatever reason, the what we call the veil of privilege is pierced, and something becomes disclosable, you haven't lost the game just by being honest or too forthright in those conversations. And now I'm just going to take you on with Cassie to settlement agreements themselves. So let's assume you've had your without prejudice and your protected conversation, and the settlement route is the one you're going down. And Cassie's going to take you through the basics of what that looks like.
So I guess, thanks, Alex. Just to start with the real basics, settlement agreements become legally binding once both parties have signed the agreement itself. And typically a settlement agreement arises where an individual has was being terminated and a payment is paid to them in exchange for them waiving their rights to bring various claims, whether they're known or unknown, in any jurisdiction in respect of the individual's employment or its termination. And as we've mentioned before, they're particularly common with senior level exits due to the complexity and sensitivity involved with their departures. So if we just take financial terms, generally financial terms appear quite early on in a settlement agreement, and they include payments such as notice, any accrued annual leave or salary being paid up to and including the termination date. More often than not, there will be a termination payment, what's also known as an ex gratia payment, to compensate the individual for the loss of employment. And that termination payment or ex gratia payment is tax-free up to the amount of £30,000. Some individuals may receive other payments, as Alex mentioned earlier, for things like bonus, commission, car allowance, even a payment for loss of office where that applies. Obviously, that's not an exhaustive list, but it will depend on the individual circumstances. There is also, of course, a clause in respect of a legal fee contribution. That's generally in the amount of £500 plus VAT. However, for senior individuals, it can range, and it may be often above that £500 plus VAT amount. Then we have the legal protections. So settlement agreements, of course, can provide legal certainty for both parties. And the individual is agreeing not to pursue specific claims against any organisation, any group companies, if that's applicable, or claims against any directors, employees, agents, shareholders, in any employment tribunal, county court, high court, or any other proceedings, again, whether they're known or unknown at the time of signing the agreement, as well as at any point in the future in respect of their employment and its termination. So whilst they're waiving their right to bring a claim, there are 3 claims that an individual will not be waiving their right to, and these should always be carved out of the agreement. And as you probably know, they're in respect of enforcing the terms of the agreement, any personal injury the individual is not aware of at the time of signing, and also in respect of any accrued pension entitlements. We've then also got other legal protections that are often referred to throughout a settlement agreement as warranties, obligations, and indemnities. the warranties are effectively promises, and both an organisation and the individual will make promises to each other, make warranties throughout the settlement agreement. They can range from the fact that both parties or the individuals agreeing not to make any disparaging or derogatory remarks, and the company or organisation will use their reasonable endeavours to make sure the same thing happens for the individual. The indemnities also include the fact that a senior level individual may be promising to resign as a director if that applies. And then we also, just to touch on the indemnities, they're essentially promises given by one party to another to compensate the other for a specific loss or liability, and that usually happens on a trigger event. So, for example, the individual may promise to indemnify the organisation for any additional tax due in respect of the termination payments, or to pay back the termination payment where there is essentially a breach of the settlement agreement or the individual decides to bring a claim. And those are just a few examples. There are a range, of course, within the settlement agreements themselves. We've then got reputation and communication. So given the seniority of the individual that we're referring to during this presentation, reputational considerations are often key, and individuals and an organisation may decide to agree internal and external announcements depending on the circumstances. Of course, references may be impacted by the level of seniority, so there may be a factual reference for a regular employee that's not senior. However, for more senior individuals, they may require a slightly more detail than a factual reference. And then, of course, we've got confidentiality clauses within settlement agreements as well. And the aim really is to protect both the individual's professional reputation and the organisation's public image when a senior individual exits, to ensure that it's a dignified and consistent narrative shared in respect of their departure. Then we have director and fiduciary duties. Of course, this only applies if the individual is a director or holds fiduciary duties, and the agreement should address the resignation from office or from those roles and confirm that duties have been discharged appropriately. There may also be a resignation letter annexed to the back of the settlement agreement and a clause confirming the obligations in that respect. And then, of course, there may be other duties such as returning company property, transferring knowledge, doing a handover. Then we have practical considerations. So these are quite standard in most settlement agreements, even for senior individuals. So settlement agreements should deal with practical matters such as the return of company property, dealing with access to systems, and more often than not, and Alex will touch upon this shortly in more detail, but there'll be a clause confirming, or should I say reaffirming, any post-termination restrictions in the individual's contract of employment because of their seniority. There may be concerns that the individual will either work for a competitor, or when they leave on their departure will take a range of employees with them. So it's important for those post-termination restrictions to be reaffirmed if necessary. And I guess just wrapping things up on the basics of settlement agreements, these are all important to ensure a smooth transition and protect the business in respect of the departure of a senior individual. And I will now hand over to Alex to address the commercial and legal considerations.
Thanks, Cassie. I think we can probably start with post-termination restrictions because Cassie has touched on that already, and then I'll move on to some of the kind of more complex areas of settlement agreements when you've got a senior individual involved. Now, they may arise in any circumstance with any employee, but more typically these are the sorts of things we see when you've got someone leaving who's at the more senior end of the spectrum. Post-termination restrictions, then, as Cassie says, the starting point is really you want to just be reaffirming the post-termination restrictions that are in place in the contract, in the settlement agreement. It isn't always that simple, however, because often the situation has changed since the employee started with us. So with senior individuals, unless they've been brought in at that level, quite often what we see is that people have been promoted and been promoted and been promoted, and then actually the post-termination restrictions that are in their contract when it comes time to say goodbye, no longer apply in the same way that they should for someone at the seniority that they are. And the critical point with post-termination restrictions is that they are reviewed as to whether or not they're appropriate based on the time at which the person signed them. So if you have someone who started as a graduate and has bog standard 6-month restrictions or 3-month restrictions or no restrictions at all, because at that point when they joined there was no need for them, that is the point at which the restrictions will be assessed. It won't be now they're a CFO, for example, and they've worked their way up from a kind of a finance admin role, 20 years ago. The judges won't care. They won't look at their current role and say, actually, clearly these are no longer reasonable post-termination restrictions. The position is very much that they have to be reasonable at the time they sign them, which is why it's so important to make post-termination restrictions bespoke and tailored to each individual that you get to sign them. In a case then where you don't have post-termination restrictions in your contract, or you have post-termination restrictions in the employment contract that you're not happy with, that's where a settlement agreement can step in and introduce new restrictions. And that might be thinking about things like poaching employees. If you've got senior individuals, they might be contemplating a team move. They might be looking at bringing other members of their team with them when they go. You may want to have stronger restrictions preventing that based on their seniority, and it might be that's something that you want to specifically address with the settlement agreement. Likewise, it might be that the competitor profile has changed since you drafted your post-termination restrictions in their employment contract, or a geographic region that you've applied in the contract is no longer applicable. You've moved offices, you've moved locations. All of these things can be addressed in a settlement agreement where post-termination restrictions can be introduced. The only thing that you will need to do in that as part of the process is assign specific consideration to the post-termination restrictions or any other obligations in the settlement agreement that are new. So if you have something that's not covered in the contract and you're adding it in, then assign specific consideration for that, because you want to ensure that part of your agreement is legally binding. And that can be anything from a nominal £1 up to £750 or £1,000, depending on the kind of severity of the restrictions and how critical they are. Broadly, the more you assign a specific consideration, the more likely it is that they'll be separately enforceable. Thinking around kind of the other complexities then of a senior exit, I'm going to briefly touch on communications. Now, Cassie's mentioned already the references point. Now, that can be more complex with a senior individual, particularly where you're in a regulated profession. You might have to give more information, and you need to make sure that a settlement agreement is consistent with that. And then likewise, thinking about how critical that person is to the business. There may be wider concerns about what you're communicating. So, and Cassie mentioned internal and external announcements, but if you've got a very senior individual leaving, you may want to make sure that they are equally bound in the settlement agreement by what the announcement says. You may want specific provision in the settlement agreement which says they can't make a press statement, depending on how significant they are to your business. So it's thinking about things like that and making sure that that's covered off, particularly if you've got a business critical person who might, go to the press and who the press might genuinely be interested in getting a statement from. So controlling the narrative is something that's going to be really critical in a senior level exit, and making sure that's covered in your settlement agreement is going to be absolutely critical. And it is another reason very often that people choose to exit senior individuals by settlement agreement rather than by a legally fair process, which wouldn't guarantee you the same kind of level of confidentiality that a settlement agreement would. I've got on their pension and retirement schemes. This is more just for reference rather than a warning. Some employers still have retirement schemes and retirement bonuses. they have gradually fallen out of favor. So it's not something that I come across often anymore. But it is something to be mindful of. If you've got a director who's agreeing an exit by settlement agreement and you are paying them an ex gratia sum, this is because pension and retirement schemes do not get the benefit of the tax-free £30,000, or at least they could be subject to tax if they were audited by HMRC. It's not something that's often picked up, but if you know an employee is retiring and they've told you that, and there's correspondence to that effect, or they've come and they've resigned and you've said, let's do a deal because we want to recognize your long service and your contributions, just be mindful that there is a potential tax implication on a 30,000 tax-free allowance, which for high earners can be, which could easily be exceeded as part of a settlement agreement. And that brings me on to the kind of tax issues. I know Cassie's already explained going through the tax of a settlement agreement and making sure that's all carefully and correctly applied. So thinking about things like post-employment notice pay, taxing holiday, and any payment in lieu of notice. With high earners, you're more likely to be over the 30,000 tax-free allowance potentially, and so it's just making sure that in the agreement you've got the tax treatment correct. They may also ask you to pay in to their pension directly to get the benefit of more latitude with how the payments are handled from a tax perspective. So you just need to be mindful of how you're framing that. And if they ask you to pay the tax pay any kind of termination payment directly into their pension, provided that there's no, if it's a company pension, for example, provided the pension scheme rules allow for that, then that won't be a problem from your perspective. But you need to be making sure that the pension contribution is covered by your tax indemnities in the settlement agreement, because ultimately you want them to have the liability for any tax, and you do not want that to fall on you, because every settlement agreement has tax indemnities. So while as a standard position, you're not liable for tax that is paid out on a settlement agreement generally, because the employee agrees to pay that back to you. The practical reality is HMRC will always pursue the employer, and the indemnity in the settlement agreement only gives you the right to then pursue the employee for the tax that you have already paid. And many of you will probably already be aware that if you have the unfortunate experience of trying to pursue an employee for a debt that you're recovering, often the exercise of recovering the debt costs more than the money you're going to recover. So just make sure it's covered off in the agreement. Thinking about shares then, this is another kettle of fish altogether, and you may find that there's a whole separate agreement in place which covers solely how shares are treated on an exit. And the key thing, my starting point is keep this as simple as possible. This is for two reasons. Firstly, the share agreement should speak for itself and shouldn't be muddled with the settlement agreement as much as possible. And secondly, because in doing that, you're less likely to incur an increased legal fee contribution for having to review a share agreement or having to review share terms, which can be quite complex. For that reason, my suggestion in the settlement agreement is that the starting point should be to say that if there are shares involved, you'll be treated in accordance with the share agreement. And then in the entire agreement clause, you'll want to be thinking about whether or not you've put that the agreement is binding but doesn't supersede the shareholder agreement, which obviously is going to remain in place in full force and effect. Thinking about things with shares, and I'm not going to go into too much detail on this, there are certain points that you're going to want to flag, possibly as part of a negotiation, and that's thinking about various share options and vesting and what happens on leaving. And that might be as simple as just sharing the share agreement that you have in place with the employee, so they can go away and remind themselves of what happens and what trigger points are where. if in the event that they leave, and under what circumstances they're leaving. Broadly, people who leave by settlement agreement where it's amicable will be confirmed to be a good leaver for the purposes of the share agreement, and then will be treated accordingly. But of course, that's not always the case. It might be that you're settling someone out to avoid a misconduct process, in which case you may want to confirm that their status upon leaving the company will be a bad leaver for the purposes of the shares. So just bearing that in mind as you go through a senior level process is really important. Just finally, kind of in terms of contractual obligations, I think Cassie has mostly covered all of these. There may be things that you want to think about slightly differently with a senior person. So maybe, for example, putting them on garden leave for a certain amount of time, or putting them to certain deliverables as part of the settlement agreement, and tying a particularly like bonus payment in exchange for them reaching that deliverable before they leave. That's all possible within a settlement agreement, and you can do that as a contractual arrangement. Likewise, garden leave, you can apply and have them basically stay at home instead of working during their notice period. But with that, you just need to be mindful that any time spent on garden leave will reduce the time that a post-termination restriction is enforceable. Well, hopefully that's given you all a good idea in terms of what you're covering off in a settlement agreement. I'm now going to pass you back over to Cassie, who's going to talk a bit about kind of managing that process. Oh, Cassie, I think you're on mute.
Sorry. Thanks, Alex. So once a settlement agreement is being considered or negotiated, it's essential to manage the process. And we've got to do this carefully to ensure that the organisation's interests are protected and to ensure a smooth transition. So there are 4 key areas there on the screen, and these are ones that need managing. So if we start with immediate absences, so in many cases, and often it's the case where there is a dispute, an individual may be placed on garden leave, as Alex was just mentioning earlier, or asked to step away from their role. And that can be for both strategic or practical reasons. The business might want to preserve confidentiality, protect relationships, or avoid disruption. So it's important to have a clear plan at that point when they go on garden leave or when they step away from their role, that their responsibilities will be covered, their IT's cut off if you want to restrict any IT access to stop them taking files with them, things like that. And this needs to be communicated to the relevant stakeholders if that is necessary. Then we've got key knowledge. So as we've mentioned throughout today, senior individuals often hold critical knowledge about the organisation and, I guess, future plans, management decisions, operational insights and things like that. So as part of the exit process, it's vital to identify what knowledge needs to be captured and transferred. Is there anything that the individual needs to hand over to a successor? Are there any documentation? Are there any documents, that need to be passed over to a successor, handover meetings, briefings, or anything like that? Obviously, where that doesn't happen, there may be operational gaps and missed opportunities. So that is pretty vital. And then we've got client management. So often, as we've mentioned, senior individuals have long-standing relationships with clients, and their exit can raise concerns and questions in respect of that. So that definitely needs to be managed as well. Key clients might want to be notified about an individual departing. And then we also have to ensure as well that any, announcements to clients need to be managed consistently with the terms of a settlement agreement. So if we've set out in the settlement agreement that an internal or external or both announcements are going to be put out on a certain date, any messaging to clients needs to be consistent with that. And then we also have internal communications. So obviously there may be questions from individuals within the organisation that aren't departing. There may be speculation and things like that. So it's important, again, to make sure that any communication's clear, respectful, and in line with what's been agreed in the settlement agreement, if that has been agreed. And yeah, so managing the process is just as crucial as the terms within the settlement agreement itself, just to make sure everything runs smoothly and the business interests are protected.
Thanks, Cassie. I'm now going to take us through the common legal pitfalls, kind of senior level exits generally, but also particularly with a review to kind of doing a settlement agreement, but maybe not getting it quite right, which does sometimes happen. So thinking more broadly before I go into the kind of elements around a settlement agreement, getting a senior level exit wrong from the beginning will just set off everything badly. So it's looking at the bit, going back to that first slide in a way of thinking of, right, how I've got a senior person who the business has now taken a decision that it's time to exit. How do we go about that? Thinking about it from the perspective of the 5 legally fair reasons, yes, there might be a route that's that's glaringly obvious. So in a case of gross misconduct, that's going to be fairly clear cut, and you're going to run that kind of process anyway. But actually, even in that scenario, it's never quite as easy as it may seem. If you've got a very senior individual, there may be reputational concerns that if it becomes known that you're disciplining them for significant gross misconduct issues, depending on what they are, that could do significant reputational damage to the business. It could also affect share price if you're a listed company. It could affect trust and confidence of others. That runs both ways, though. So if you've got a senior individual who's committed gross misconduct and in a scenario where other people are aware of it, you may have to act in a certain way, even if you might rather do a settlement agreement, in order to ensure that others know that you're dealing with it appropriately and as it should be done. So there's different ways to think about how you exit a person at a senior level, and I would always say take care to think about how a legally fair process can be run and whether it's going to be appropriate with someone with potentially quite a significant impact in the business. And that's why we look at settlement agreements. But what we quite often see is before we even get to the settlement agreement, people using without prejudice or protected conversations in the wrong way, or effectively voiding them in the way they're approaching the conversation. I'll start with protected conversations under section 111A, because as I mentioned, they don't cover and can't be used to cover anything that might be discriminatory, anything that might be covered by whistleblowing legislation. And so if you've relied solely on without prejudice, on protected privilege, and you are covering issues that might be discriminatory, and with senior exits, this is where you tend to come up against accusations of age discrimination, for example. That's where protected privilege falls short. Thinking about without prejudice, there is a much higher bar for something to not be without prejudice, but effectively the way to think about it is if you're using it vexatiously, if you're using it to pressure them to sign a settlement agreement, if you're using a conversation purporting to be without prejudice, but you're effectively saying if you don't sign this, we'll terminate your employment and there won't be any process, then there's a potential that a judge will say that that conversation was not properly without prejudice because the conversation was malicious or vexatious in terms of how it was had. So just being mindful of what I said before, which is if you're going to have a conversation that's protected or without prejudice, it's absolutely fine to push the line a bit further than you would if you were having an open conversation. But always bear in mind that what you say may come out in certain circumstances, and if you live by that rule, then you're never going to go too far wrong. Assuming then you kind of get into the world of you've got the settlement agreement in place, one of the common things that we see with senior exits is inadequate settlement agreements. So people using a standard template that you would use for anyone. There are things that you're not going to capture in a standard settlement agreement, in the same way that a standard employment contract doesn't cover directors' fiduciary duties, because the majority of your employees won't be directors. A settlement agreement is exactly the same. A standard settlement agreement is not going to cover the things you need covered when you're exiting a senior employee. Thinking about director and governance, in particular, if you've got a company's house, a director, a statutory director, there are certain obligations around resignation that you might need. You might need a settlement agreement that's actually a deed, because you're going to include a power of attorney, which gives the company the right to effectively resign them on their behalf from company's house. Now, a standard settlement agreement, which isn't witnessed, is not going to give you that power, whereas a deed, which is signed and then witnessed by another person, when both parties sign, that will give you that power of attorney right to then resign someone from company's house. So not having that in place, I mean, if it's amicable, it's not going to be the end of the world, but in a difficult dispute where you've exited a senior individual by settlement agreement, where they didn't really want to go and neither party is particularly happy by the outcome, not having that ability to resign them from company's house and then them refusing to resign could be problematic. And then, as we've mentioned, thinking about contractual entitlements, a standard settlement agreement is probably not going to cover everything you have in place for a senior individual. So just bearing that in mind when you've got a settlement agreement. And finally, kind of poor or inconsistent communication. Now, this is one we see a lot with senior exits, particularly where you've got kind of board level people leaving. They are understandably very conscious of their reputation in that scenario. And so negotiating an announcement, whether that's internal or external, can be actually quite a critical part, sometimes even more than the financial terms, during the negotiation. If you've gone to the trouble of agreeing it, particularly where you've got someone on garden leave for a long period, for example, it is absolutely critical that everyone who needs to know knows what the announcement is, what is the party line, how are we conveying this, how are we talking about this, because it can derail an entire process if afterwards very publicly another director has said something about the exiting director, for example, that isn't in line with what is agreed. Effectively, that becomes a breach of the settlement agreement, and there's an argument there to be had about whether the settlement agreement remains legally binding and whether both parties can have the benefits of it. And then finally, kind of just thinking about potential employment tribunal claims. Now, hopefully, if you've got a good settlement agreement in place, this won't be so much of a concern. But the reason this is on there is when you go through a senior level exit and you have decided to do a legally fair process rather than a settlement agreement, this is where you might need to think about the risk profile, because just by virtue of the fact that someone is very senior, their salary is likely to be higher, and therefore value of employment tribunal claims is going to be high. In terms of discrimination and whistleblowing in particular, the losses, as you will all know, are uncapped. Where you combine that with a situation where you've got someone who potentially has gone through a process and suffered reputational damage such that they can never work in the industry again, you've got the perfect storm of uncapped compensation for injury to feelings and discrimination in discrimination whistleblowing cases, a very high salary, potentially in an unfair dismissal claim, so you're already at the cap for that, and then loss of future earnings if they can't work anymore because of a misstep in a process, which has resulted in reputational damage. Those awards can be exceptionally high, and it's those awards that get us all into trouble on the standard settlement agreements, because they're the ones that are picked up by the press, where senior level executives are getting awards of 2 point whatever million. Those aren't standard in the employment tribunals. We all know, usually, tribunal awards are within the tens of thousands, but it's those big awards that are often triggered just because a person is senior, and therefore the level of money involved is just higher by virtue of having a higher salary, having a higher bonus, and then having the loss of that, that means in a senior level exit, a potential employment tribunal claim could be 3 or 4 times the commercial and financial risk of exiting as a standard employee. I feel like I've ended on a bit of a scary note, but the good news is, with following the kind of managing the process tips that we've given and identifying from the start what the best route to go down is, hopefully means you can take steps as you go through to mitigate the risk of any kind of employment tribunal claim, and ideally settle that risk before it even arises. And now I have perfectly timed this. We have perfectly timed this, I should say, to open up the room to questions. So if anyone has any questions, then please do feel free to pop those in the chat box, and Cassie and I can deal with those. Or if you want to put your hand up and speak, we can unmute you. So it's totally up to you. Oh, this is always the way. Someone's got to ask a question first. I'm sure Cassie and I are excellent, but I don't know if we can do a whole presentation without having any questions. Great, Cheryl. Toby, are you okay to unmute Cheryl?
Hello?
Hi, Cheryl.
Hi. That was an absolutely fantastic presentation. Thank you so much, and quite
you.
timely in terms of my experience. So I am a non-exec director on a board. There has been a complaint raised about one of the SLT members. The decision has been taken for some strange reason not to investigate those concerns. But in terms of exiting that NED, what are the risks, considering that the role is voluntary?
So a NED is slightly lower risk because, as you say, it's a voluntary role. They're often not in the organisation every day, often can be part-time. So managing it can be easier in some ways. And also because they're often not so not there every day, they don't have the kind of salary usually that that causes problems with kind of permanent employees who are there all the time. I think the risk profile is largely the same. It's going to be thinking about things about how you sell it effectively to the rest of the business. In terms of the concerns, it's a really difficult one because it depends on what the circumstances are, Cheryl, and I don't want to force you to go into the details. So if you want to take this offline, you can I can pass you my email address, or hopefully you'll have this and we can talk about it in more detail. But if there are concerns, like, obviously I'm not going to put words into your mouth about what it might be, but just taking one where you've got a legal obligation. So the Worker Protection Act came in last year. You've now got a legal obligation to prevent sexual harassment in the workplace. If the concerns were of that nature, then that's a much higher risk profile than if it's just he said something nasty or she said something nasty about someone and it's created a bit of a bad situation. In a scenario where you've got potential sexual harassment, you've got to investigate it. You really don't have any choice, because you open yourself up to a wider risk with the rest of your workforce for not taking the proactive steps you need to prevent sexual harassment in the workplace. So I think it does really come down to assessing kind of what it is that they're not investigating and why, and is there a risk within that of not doing it? And if there is, how do you mitigate it if you still don't want to investigate it? And that might be by, having a document somewhere that says we considered this and for this reason we didn't do it. Just having that document is always helpful. So you've got someone documenting the thought process. It might just even be an email to the board saying we've all discussed this, we've all thought about this, and these are the business reasons that we've decided to do what we've done. And then I would probably still, even though they're a NED and they might be lower risk, I'd probably still be looking at managing it through a settlement agreement. Or if they, sometimes people are fairly amicable about stuff, and if they get called out on something they know they've done wrong, they'll just agree to resign, and you can have sort of protected conversation through that route, if that makes sense. But it's so circumstance specific, Cheryl, that it may be that if I drop you an email after this call, we can have another conversation about it, if that helps.
That sounds great.
Lovely. I can see this. Max has asked a question about how we can stop colleagues from sharing confidential information they know about. That's a really good question, Max. It is ultimately really difficult to stop people from talking. I wish it was easy. There's no easy answer, is the honest truth. But what I would say is to give yourself the best protection to address it. If it goes wrong and someone does talk about things they shouldn't be talking about, is to reiterate any kind of confidentiality obligations that you've got in your employment contract to anyone that learns about the information in terms of a settlement agreement, for example, or a formal process. At every point in that process, whether it's settlement or otherwise, remind people of the confidentiality obligations, remind them that breach of confidentiality can be subject to separate disciplinary proceedings, and really just, if you think, oh, I'm speaking to this person about a settlement agreement because, let's say, they're my payroll administrator and they have to actually pay the money out, then just remind them at every stage, this is confidential, this is absolutely confidential and must not be discussed. And while I wouldn't be saying at every conversation, breach of the confidentiality obligations that you have to adhere to is a disciplinary offence, I would very much be reminding people at the outset, if you know it's a concern, because it just sets the tone of how seriously you're taking things. And I've given the example there of using a payroll assistant because they're paying out the money, but actually very often board members fall foul of this as well. So, have that conversation at the beginning, even with your most senior team, about how confidential things are, and just be upfront about that. Aside from that, Max, if you find a better way of stopping from people talking about things that they shouldn't be talking about, please do let us know. I can see there's another question. Toby, are you okay to unmute? I'm sorry, I can't see the name.
Hi, it might be me. It's Kester.
Yes, Kester. There you go.
Yeah.
You've come up big now. I can see you.
All right, great, thanks. So look, I first of all echo Cheryl's words there, which is great presentation. Thank you, and very timely for us as well. So thanks, Alex. Thanks, Cassie. I had a quick question about the asking people to leave the business as a direct outcome of the meeting you have, so place them on garden leave. From past experience, I find that does derail people very quickly in terms of having that conversation. They've taken a lot of information in. If it isn't a conversation they're expecting to have, then often that can cause. I found problems with people then finding dispute, finding reasons to come back at you, and whether you have, they've got the settlement agreement there in front of you or you're going to send that to them. I just wonder, are there circumstances where you may, and that probably does depend on whether you're dealing with a capability issue or a pre-existing dispute. Are there circumstances where someone can stay in the business for a period, or is it recommended they're placed on garden leave straight away? Can that have an impact, a negative impact on what you've tried to communicate and how you've tried to frame this with them? Is guess what I'm saying. Is there a way to do it? Is there a way to sort of to manage that? And also, there's kind of like what you need to line up before you ask them to leave the business. I don't know, just in terms of what you need to cover and work and stuff, etc. Sorry, there's a lot there. I'm just thinking.
No, don't worry. It absolutely makes sense. So you can absolutely still have people in the business, even if you're going through a kind of settlement discussion with them. In cases where it's sort of, even if it's unexpected, but it's sort of amicable, you can, excuse me, you can run through that. You can run that process while keeping someone in the business. It's all going to come down to expectation management in that. So, I would probably, if you think the conversation is going to come as a shock to someone, you don't have to necessarily put them on garden leave straight away. But what I do typically say is, offer, just say that I appreciate this has come as a bit of a shock, this conversation. So what we're thinking about is for the next couple of days, we'd like you to go on authorized paid leave for a while, have a think about what we've talked about. In that situation, Cassie, you might not want to give them a settlement agreement straight away. You might just want to actually just give them the high level terms, say, this is what we are thinking about, this is where we are. Go away and think about it for a couple of days. Go have some authorized paid leave. Think about what we're saying. If you decide actually you want to go down a settlement route and you're happy to agree those terms, then we can send you a settlement agreement which incorporates everything. In a conversation which is going to come as a complete shock, that's sometimes a softer way to do it. And then after when they're on authorized paid leave and they start to ask you questions and they start to engage with it, ideally if there is something you want them to do still in the business, then that's when you can have that sort of conversation as a follow-up and say, look, we want to manage this in such a way that we have we have these sort of things that we'd like you to help with. You can do those from home if you want to, or if it's something that you need to come in for, we can facilitate arrangements for that to make them feel comfortable with it. It's really just going to be about expectation management. If you go in and you shock them and you give them a settlement agreement and they just immediately get their back up, then I think in some cases it's not worth getting them back in the office because they're going to be a disruptive influence. And it could be worse for the business to have them back than it would be to just have them on authorized paid leave before you kind of have that conversation. This brings me on to a good point though, Kester. I would always, when you're having with that prejudice conversation and you are doing some kind of open process along at the same time, I would always refer to any absence of authorized paid leave rather than garden leave. And that's because garden leave has a connotation of notice. If someone's on garden leave, they are effectively staying at home and serving their notice period, but not working. And that's potentially fine in a purely without prejudice situation where you're saying we're effectively agreeing the termination of your employment up front. But if you're positioning it as we'll do a performance improvement plan, for example, and we'll do that for 3 months on the one hand, on the open side, but then on the without prejudice conversation, you're saying here's a settlement agreement and now you're on garden leave, they could argue that use of the word garden leave shows that you've already decided that they're going to be terminated at the end of the performance process. So just always refer, my top tip there would be think about it in terms of authorized paid leave until they've actually signed the settlement agreement, and then you might keep them on garden leave rather than having them kind of paid in lieu of notice, for example.
Great. Perfect.
Does that make
sense? That's really helpful. Yeah, totally does. Brilliant. Thank you.
Likewise, Kester, if you want, I can drop you an email after if you have any other questions, and then you can ask Cassie and I directly.
Sure. Fantastic. Thank you.
Lovely. I think that's it for the questions. So thank you all very much. I should have said at the beginning, we'll circulate the recording and the slides as well. So you can have access to the material as well after the training. Thank you very much.
Thank you.